honored to introduce Ned Blackhawk, currently the Howard R. Lamar Professor of History and American Studies at Yale University. But since there's been some UW questions in the room, his PhD is from University of Washington. His first tenure home is UW-Madison. So go W's. Because in this setting, Ned's partner, the brilliant NYU law professor Maggie Blackhawk, may be better known. I'm going to briefly tell you a bit more about Ned Blackhawk and why we're so excited to have him as our plenary speaker. Ned's work does exactly what we hope that this annual meeting will do, and that what we think of as a core goal of the Law and Society movement. It unsettles the geographic and ideological territories and categories presented as settled, as natural, as inevitable. And it shows how peoples understood as peripheral to the U.S. law and society were in fact at its center, interacting with and shaping the U.S. In diverse and impactful ways. So so I think his talk today is going to be drawn from his 2023 book, The Rediscovery of America, Native Peoples, and the Unmaking of U.S. History, which among about a dozen or so honors won the 2023 National Book Award for nonfiction, was the New Yorker Best Book of 2023, and the National Public Radio Book We Love for 2023. I also want to highlight his 2006 book, Violence Over the Land, Indians and Empires in the Early American West. The book also won a bunch of prizes, including the Frederick Jackson Turner Prize from the Organization of American Historians and the Native American and Indigenous Studies section Book of the Decade Award. But equally important for this meeting, it focuses on the place where we are now and the peoples where we are now. The mountain states of Colorado, Nevada, Utah, and northern New Mexico and northern Arizona, and the interactions between the settler and indigenous communities of this place, including his own people, the Western Shoshone people of Nevada, or the Niwa people, and just read it. So I checked out the book room. Apparently, it's not being sold. Neither of his books are being sold there, which is probably okay for you because particularly the most recent one is super heavy. But you can go, and you don't want to travel with it, but you can go on with the internet or with your phone and download it. And so I've got 2 copies, one physical and phone, and they're so readable. They're so wonderful. And I'm not going to talk more about the other articles and book chapters Ned has written or the many other academic prizes he has won, because I don't want you all to get too depressed. But just want to note some of his accomplishments in supporting others in academia and outside it. So while a professor at University of Wisconsin-Madison, he both won the Outstanding Mentor Award and served in the Intercollegiate Athletics Faculty Guest Coach Program. I don't know what that means, but it sounds cool. While at Yale, he was founding editor and is now co-editor of the Henry Rowcloud series on American Indians and modernity at Yale University Press. For several summers, he coordinated a seminar on American Indian history since 1492 for New Haven Public School teachers, and he currently serves as co-director of the NYU Yale American Indian Sovereignty Program project, which since its founding has submitted multiple briefs to the U.S. Supreme Court to try to get them to get the history of Indigenous peoples in the United States right. So thank you so much, Ned, for being here. And my fabulous co-chair will say a few words afterwards, but please come on up.
Hello. Thank you so much, Professor Berger, for that very kind and generous introduction. I think I might have two mics going because I would like to try to be a little interactive halfway through this presentation to kind of keep the attention span um, uh, elevated. Um, but it's really a tremendous honor to be here today, and I'd like to thank, in particular, the program committee for the invitation to offer this plenary or keynote address. This year's conference theme, Unsettling Territories, Tradition and Revolution in Law and Society, provides, I hope, an apt framework for engaging the intersecting streams of legal, political, and intellectual activism that characterize the concluding portions of my recent book, The Rediscovery of America, Native Peoples and the Unmaking of U.S. History. This project, as Professor Berger so generously um, suggested, examines various forms of U.S. and Native American historical development and attempts to conjoin them rather than seeing these fields as separated or disaggregated. This project envisions them as interrelated and relational. And it attempts to highlight, as I hope to show today, their mutually constitutive nature. Denver is appropriately and additionally an important location to interrogate these processes, as many underrecognized forms of legal advocacy and activism have occurred here throughout the late 20th and early 21st centuries. Such advocacy followed, as your program committee programmers, your program highlights, waves of 19th century forms of dispossession that have made Colorado relatively unique in having few federally recognized tribal nations within its borders. Of the 46 federally recognized tribal nations within the 6 Rocky Mountain states of New Mexico, Wyoming, Utah, Idaho, Montana, and also Colorado, Colorado has only 2, the Southern Ute and Ute Mountain nations in the Four Corners regions. These figures of 46 federally recognized tribes also do not include the 21 native nations of Arizona, including the Navajo Nation, the nation's largest reservation in America, whose reservation boundaries and thus jurisdiction reach into all 4 states. The Rediscovery of America attempts to interrogate such broad, sweeping forms of historical development. And the book builds upon a generation of studies to make a series of claims about the centrality, as Professor Berger was saying, of Native peoples to the making of America. Drawing upon works, numerous works, it suggests that a new theory may ultimately be needed to understand the contours of U.S. history more broadly. And the book's first front and back cover maps were developed in part to bring the incomparable expanse of this subject together. There have been, as some of us may know, few attempted overviews of Native American history more broadly. The field's incomparable temporality, spatial dimensions, and ethnographic heterogeneity have seemingly discouraged historiographical interpretation, leading to, as I think we may all know, the field's general invisibility to American scholars and citizens alike. Starting in the 1990s, however, studies in the field began to resonate so powerfully that they have enabled now scholars to develop new interpretive paradigms, including the field of settler colonialism that has, as some of us may know, origins in the field of Indigenous studies. It has enabled scholars to additionally fashion broad, regionally based histories like those of the Colorado Plateau and Great Basin that are featured in my first work, Violence of the Land. Thank you, Professor Berger, for that generous plug. And it has finally also enabled scholars to contribute to what I call a vast rediscovery of major periods, themes, places, and ultimately human communities. A rediscovery that has been particularly transformative in the field of early American and borderlands history. Native American history, in short, has become a flourishing field of inquiry, and its insights unsettle or unmake operative assumptions about America. Notwithstanding this broad trend of professional growth, the field still remains encumbered by many challenges. In particular, the habits of previous generations remain often calcified. When synthetic undertakings of American history continue to exclude Native peoples, the study of America grows ever weakened. To perpetuate visions of North America without discussions of dispossession, colonialism, or the dialectics of state formation and indigenous resistance reinscribes what I have termed the iron cage of erasure, a historiographical habit that elides central dimensions of the North American past. Of course, relegating indigenous peoples outside of history remains a long-standing practice of U.S. intellectual history. And my talk today draws from the last two chapters of the Rediscovery of America, a book that is divided into two 6-chapter halves. The first half is entitled Indians and Empires. It surveys this kind of borderlands, early American world, and focuses upon changing relationships between Indian and imperial powers before 1787. The second half of the book, Struggles for Sovereignty, focuses upon changing relationships between the United States and Native nations thereafter. And unlike in some audiences, I believe I don't have to emphasize why 1787 serves as a key periodization for such divides. As in the other chapters, the latter sections of part 2 attempt to move past what I see often as overdetermined analyses of indigenous victimization and subjection. I emphasize less the power of settler colonial dominion and more the dialectics of Native American activism, exposing here how after the Civil War, indigenous peoples responded to and thus refashioned, as we'll see today, the institutions of federal authority around them, particularly during what is known as the reservation era, when the federal government began systematically attempting to incorporate Native peoples into the body politic of the United States. As many have illuminated, federal leaders such as Captain Richard Henry Pratt, the founder of the Carlisle Indian School, sought to transform Native people's most intimate ties by severing what Professor Kathleen Cahill has written as the, quote, effective bonds between Native children and their families. New laws targeted communal landholdings, and for half a century, removing Indian children from their families and alienated reservation lands defined U.S. policy. Over 75,000 children were removed to federally funded boarding schools, and 100 million acres of reservation lands became further dispossessed, including the vast majority of the Confederated Ute Reservation established here in Colorado by the 1868 Ute Treaty, which was ratified by the U.S. Senate in July of 1868. On the same day, the Senate ratified the historic Navajo Treaty, creating the largest reservation, what would ultimately become the largest reservation in America. By the end of this period, or towards it, Congress had placed Indian communities under their, quote, absolute jurisdiction and control, as Public Law 219 suggested, in a legal doctrine that is well known across the field, known as plenary power, that informs numerous studies in the field. So my talk today draws upon this half-century assimilation campaign when a generation of indigenous activists responded to these destructive policies and shaped the contours of federal policy thereafter, particularly during what is referred to as the Indian New Deal, when reformers both reversed assimilation and established new statutory foundations for cultural autonomy and self-determination codified into congressional statutes. I started in the late 1800s when the United States experienced unprecedented economic and cultural transformations. 10 million attended the Centennial Exhibition of 1876 in Philadelphia, for example. reveling at its majesty of visions of the American future. And twice as many attended the spectacular White City Exposition held in honor of the 400th anniversary of the Columbian encounter, organized on Chicago's waterfront, from which the next few images are drawn. Even before the 1890 census declared the frontier to be closed, or Chicago held the Columbian Exposition, sweeping new visions of American history were proliferating across the post-Civil War era, making it one of the most kind of formative moments for the ideological foundations of what we would call eventually American history. With each centennial monument, celebratory parade, and publication, visions of a confident and certain past deepened across the land. Indeed, throughout the 19th century, new mythologies emerged as everywhere citizens celebrated the origins of the Republic and often equated its history not only with progress, but often providence. Even the nation's first professionally trained historians shared many popular truisms. They too located the nation's defining characteristics in the colonial era and believed that the settlement of Indian lands formed the basis of America's fulfillment. As I write, in a morality play with foregone conclusions, the United States emerged from the conquest of Indian lands and achieved its destiny through expansion. As many here know well, a broad consciousness of this process of interior expansion fueled not only the nation's historical production, but also even its scholarly infrastructure, which included the establishment in 1907 of the Mississippi Valley Historical Association, which later became the nation's largest professional history organization, the Organization of American Historians, whose journal now eventually became known as the Journal of American History. Within such studies at the time, Indians were not simply outside of civilization, as our slide hopefully can suggest, but antithetical to it. It is only from the study of barbarous nations that we are able to comprehend man as a progressive being, summarized the incredibly influential California historian Herbert Howell Bancroft in his 5-volume series, The Native Races from 1883. From Iroquois in the Northeast to Alaska, across the continent, North scholars sought to identify how native peoples differed from, quote, civilized man. As Bancroft suggested, for example, among the Alutiiq of Kodiak Island, their domestic manners are of the lowest order. They have no idea of morality. They lived, he concluded, simply in filth. Within the structure of America's racial hierarchies, Native peoples inhabited the lowest rungs, constituting in many ways living object lessons about American racial hierarchies more broadly. They remain members of a vanishing race in need of reform, and like the nation more broadly, they too shared a destiny. If they could not assimilate, they were destined to disappear. Native peoples, as Arizona Senator Carl Hayden argued in the early 1920s, were a, quote, dying race entitled to little else. So visions of Native peoples' presumed disappearance shaped the ideological terrain upon which Native peoples themselves had to navigate life in modern America. Raised with their own distinctive cultural practices, kinship networks, and alternative understandings of landscapes and the past, a generation of Indian leaders countered these false premises of U.S. history and challenged the assimilation policies and legal systems that often accompanied them. Educated in the schools designed to assimilate them, this generation articulated alternative understandings of the past and thus future. As the Oneida leader Laura Cornelius Kellogg asked in her 1920 work entitled Our Democracy and the American Indian, "But what shall I say to you now, America of my Americans? Shall I fawn upon you with nauseating flattery because you are rich and powerful? We are dubbed a race of beggars," she continued, while encouraging Native peoples in this text to, quote, refused to allow, end quote, such representations of their inferiority to go unchallenged. Kellogg was a founding member of the Society of American Indians, the nation's first intertribal political association, founded in 1911. And she and its founders worked within their own and other communities to challenge not only federal policies, but national myopia. They wrote books, delivered sermons, held meetings, traveled widely, went to court, and lobbied in Washington. And alternative understandings of politics, law, and history animated their activities. Many, like the Dakota author Zeke LSA, also known as Gertrude Bottom, targeted what she termed the, quote, institutional incompetence of the federal government's Indian policies and administrative structures established to incorporate Native peoples into the Union. As she wrote in her 1921 collection, American Indian Stories, government fraud of Indian, quote, lands, mines, oil fields, and other natural resources was as commonplace as it was illegal. Such mismanagement, she concluded, is, quote, almost beyond the possibility of comprehension, end quote. So within the structure, wrong page. Other society members challenged myths of disappearance by educating children differently. Here's Laura Cornelius Kellogg, Gertrude Bonham, an Ojibwe lobbyist and government employee in Washington named Mary Louise Botno Baldwin, who appears prominently in Professor Cahill's recent book, Recasting the Vote, and Elizabeth Bender Kellogg, also an Ojibwe performer, but from northern Minnesota, who, along with her Ho-Chunk Indian partner, Henry Rocloud, whom we'll hear about shortly, established a preparatory school to educate Indian children differently, known as the American Indian Institute in 1915. It offered advanced academics, not vocational labor, and culturally enriched pedagogy. And it lasted until the Depression crippled its viability as well as its planned attempt to admit women. So collectively, as I cover, this generation offered affirmative visions of what many scholars would now refer to as indigenous futurity or futurities, that envision Native peoples not as objects of victimization, but as agents of historical change. In doing so, they challenged the grammar of white supremacy while laying, as we'll see hopefully shortly, the ideological foundations of the reforms of this New Deal era. And I focus here on Kellogg, Rocloud, and a Wallapai Indian veteran from World War I and deep critic of Senator Hayden named Fred Mahone, whose activism generated new doctrines of what became known as Aboriginal title throughout a decades-long process of legal advocacy and activism that culminated in new Supreme Court rulings and subsequent congressional laws. And I excavate their very capacities in order to underscore these dialectics of activism and how they inform the political formations that often came to govern Native peoples, doing so often within unwelcoming and violent institutional settings. We'll come back to Rocloud in a minute. But as many of us know, the studies of federal Indian policy have often disproportionately focused upon the actions of government officials, not Native American intellectuals, community members, or activists. Studies of BIA Commissioner John Collier or Interior Solicitor Felix Cohen dominate the broad understanding of the Indian New Deal, and only recently have studies come to gauge the influence of Native activism upon such determinative realignments. I hope to suggest that analysis of these processes does more than simply recover overlooked forms of agency, and that such a kind of inquiry hopefully can help historicize the mutually constitutive processes that ultimately helped to govern Native communities. And in the process, we might perhaps begin to denaturalize, as Professor Berger was suggesting, some of our normative assumptions about American power, difference, and social change. On to Kellogg. Laura Cornelius Kellogg spent over 2 decades lecturing, publishing, organizing, and advocating on behalf of Indian affairs. She notably hosted the Society of American Indians' first organizational meeting in her Wisconsin Oneida home in June of 1911 and became one of its primary leaders thereafter. And she took particular issue with ideas at the time that suggested the need for incremental reforms within Indian communities and the potential adoption of certain assimilationist philosophies. For her, cultural continuity, not assimilation, characterized the necessary strategies for rebuilding the capacities of Native peoples within reservation communities. After the First World War, she joined a network, for example, of Iroquois leaders fighting for land reforms and founded something called the Six Nations Club that aimed to raise funds from individual tribal members from across the Iroquois communities of North America, who historically have resided largely in upstate New York, but also Canada, Wisconsin, and Oklahoma. She proposed to use such funding for the litigation of ongoing Iroquois land claims. The claim at the time was a recent decision by a U.S. Circuit Court of Appeal in the Second District called U.S. v. Bolin, in which Iroquois leaders had encouraged federal officials in New York to file suit on their behalf over a contested 32-acre parcel of land, which Oneida leaders in New York claimed had never been formally dispossessed. The state had tried to sell it and evict Oneida members upon it. And in the district court ruling, the court held that the lands in question could not be sold as the state lacked jurisdiction over Oneida lands, and only the federal government, through its doctrines going back to the Non-Intercourse Act, possesses, quote, the sole authority to dispose Indian lands. The decision was upheld on appeal. She continued her fundraising efforts to secure this victory and also joined reform efforts in New York State, particularly those in 1922 by a state assemblyman by the name of Edward Everett, who led a commission that aimed to clarify the state's outstanding Iroquois land claims. Of the 27 Iroquois land cessions that have occurred within the state of New York, the Everett Commission found that only 2 had consent or approval from the federal government. That's calling into question the constitutionality of the other 25. A series of land cases have followed throughout the 20th and 21st century that have exposed these unconstitutional takings. And if we have time, I will kind of come back to this theme to discuss the 2005 case, which is the most recent of these claims, called City of Sherrill versus Oneida. Rocloud, who took a different kind of philosophical and ideological turn. Unlike Kellogg, who advocated for the abolition of the Indian service within the federal government, sometimes encouraged tribal members not to pay their taxes to the federal government because she felt they were intrusions against Native American sovereignty, and kind of focused so heavily on building reservation self-governing capacities and economic forms of self-governance. Rocloud worked within the government, particularly after his time as was he shortly at the American Indian Institute, which he founded in 1915 with his partner, Elizabeth Bindercloud, whom he met at a Society of American Indian meeting itself. He even aspired to be the Commissioner of Indian Affairs in 1928. Born on the Ho-Chunk or Winnebago Reservation in Nebraska, he was first schooled in boarding schools before gaining sponsorship to attend the preparatory school in Massachusetts known as Mount Herman School. And he entered, of all places, Yale College thereafter. Bless you. Becoming in 1910 the school's first Native American graduate. And in other settings, particularly with Yale undergraduate students, I might dwell upon this in some form. I might say things like, who might he have known when he was at Yale at this time? He was apparently close friends with a future senator from Ohio, for example, by the name of Robert Taft, who almost became the Republican nominee for president in 1952. Um, he and Taft were close. I don't know exactly how close, but clearly friends and peers. They debated and traveled, and in the yearbook of 1910, it kind of lists their home addresses after giving a brief bio of each graduate. And Roe Cloud was sponsored by a missionary family called the Roe family. So the Roe family is listed as his home address. And I asked the students, where do you think Robert Taft's home address was in 1910 when he graduated from Yale College? Anyone know what address? The most famous address in America is 1600 Pennsylvania Avenue, because he was the son of Howard Taft, the sitting U.S. president, former commissioner of the Philippines, and future Supreme Court Chief Justice. These are the individuals whom Roe Cloud was socialized around. And rather than following them into careers in, I don't know, finance, Philippine sugar oversight, government, he built a school in a rural Wichita, or at the time, Wichita, to create alternative educational experiences for Native peoples. Because his varied educational experiences had clarified to him the necessity of these imperative reforms. Having seen, for example, at age 5, his older brother seized by local police and sent off to school, Rocloud soon followed. Washing clothes, working in laundries, and related vocational labor did not offer him, he felt, much education. It nursed what he called a, quote, growing hatred of the monotony of boarding school life. Such work is not educative, he wrote. It in fact, quote, begets a hatred of work, as he had seen as a student and subsequent government investigator, quote, industrial, or the so-called industrial education exploited youth and ill prepared them to, quote, grapple with their community's problems, end quote. Both he and Elizabeth Vindercloud hoped to strengthen then tribal capacities by educating children differently. And the Clouds traveled widely and worked extensively, both at the Indian Institute and other Indian educational facilities thereafter. In one address to a graduating class of Native students at Mount Edgecombe School in Alaska, he communicated his philosophy to strengthen tribal capacities by educating children differently. Never be ashamed, he told them, that you are an American Indian or native of Alaska. He traveled widely on behalf of the government, often investigating problems within reservation communities. For example, investigating conditions and reports of abuse at boarding schools themselves. As he reported from Rosebud, South Dakota, conditions were awful and punishments worse. Student runaways were common, and several boys had recently, quote, froze to death by running away. Shortly before he arrived, quote, 3 girls ran away, end quote, and upon their return, one was made to, quote, carry a ball and chain around her ankle while pushing, quote, a wheelbarrow for hours in front of the whole school, end quote. Breaking the punitive structure of education was his and Elizabeth Vandercloud's imperative. And upon his appointment eventually as superintendent of Haskell Indian Institute in Lawrence, Kansas in 1933, then the nation's largest Indian boarding school following the closure of Carlisle, he expanded upon these philosophies and developed over the previous decades. In his first act, he closed the Haskell Jail, which, like many boarding schools, was built to imprison and incarcerate Indian children. He dismissed also school employees known for harsh discipline and distanced Haskell from the local National Guard unit, which had supplied uniforms, officers, and drilling equipment that were often utilized by Pratt and other boarding school leaders. Located in Lawrence, Kansas, he also cultivated relationships with nearby educational institutions. And by 1935, after only 24 months, 28 Haskell graduates had gained admission to the University of Kansas for college education. Here are one of the last graduating classes of the American Indian students in front of one of the buildings built through their fundraising and very determined organizational and administrative efforts. Rocloud, however, is best known for his co-authorship of the 1928 Merriam Report, the most thorough report ever authored on the state of Indian affairs in America. Begun in 1926 at the bequest of the Secretary of the Interior and conducted by the Brookings Institute, it leveled devastating critiques of federal Indian policy, laid bare the impacts of assimilation, and provided much momentum for the subsequent reforms that followed. Henry Rocloud's fingerprints are all over this report, and he is the only Native American co-author, along with 7 other non-natives, on a survey that helps, I think, communicate the law and society kind of challenge of Indian affairs at the time. The report, often referred to in honor of Henry Merriam, one of the lead authors, was entitled "The Problem of Indian Administration." And in preparation for the report, he visited more reservation communities than any other committee members, spent the entire summer of 1927 commuting from Maryland to Washington to write the report, and eventually, eventually shape its ideological tenor. There's a close relationship between the loss of land and the health and prosperity of Indian people, he concluded, and improving the health and prosperity of Indian people guided his and Bender Cloud's activism throughout the latter half of their career. And I could continue to kind of explicate the kind of myriad ways in which Rocloud's kind of philosophies and practices helped guide the subsequent reforms of this Indian New Deal. But we'll introduce in closing, before doing so, the last primary subject of this generation of activists whom I'm discussing, a Wallapai veteran by the name of Fred Mahone. For those of us who don't know, the establishment of the Roosevelt administration's first cabinet and organizational leaders set in motion the kind of radical revision of the sets of assimilation policies that I've just sketched. The land policies of allotment became reversed during the New Deal. Many boarding schools themselves were closed, and perhaps most importantly, a series of legislative congressional efforts were established, most notably the Indian Reorganization Act, the kind of monumental, what some might call super statute of congressional legislative constitutionalism that established for the first time in American history a congressional statutory basis for working for the federal government to work with tribal nations as self-governing units. And the IRA was followed by a series of attempts to encourage Native American communities to adopt tribal constitutions that Felix Cohen, John Collier, and Henry Rocloud often encouraged tribal communities to do. And so Cohen, as we'll see shortly, Collier, Rocloud, and numerous members of this generation of activist communities worked diligently and closely throughout the New Deal era to establish a distinct alternative form of federal Indian relations that ultimately laid the seeds of what we now would call self-determination, an era that became more kind of institutionalized in the later 20th century, but really has its primary statutory, if not ideological, foundations and origins during this period. Cohen not just litigated and drafted, but also studied the problem of Indian law and policy and codified them into a government publication known as the Handbook of Federal Indian Law, first published by the U.S. government printing office in 1941, which literally brought the field together into a single kind of codified form for the first time and gave judges and policymakers uh, and, and colleagues, essentially, and eventually academics, a framework for understanding the evolution of this longstanding subject known as federal Indian law, which has its roots, at least constitutionally, in the summer of 1787, when the Constitutional Convention brings Indians into the Constitution formally twice that summer, and eventually later in this 14th Amendment in the Reconstruction era. So Indians are in the Constitution. Some of us may know they're recognized in the Declaration of Independence. These are not seemingly invisible subjects of legal inquiry, but seemingly have been put there in some form or fashion that has been, I think, not entirely helpful. And if we were to look and conclude with one last example of a Native American activist, intellectual, community member who had an alternative vision of American Indian capacity, alternative vision of U.S. history more broadly, and a vision of the future that was distinctive from that of federal policymakers at the time, I think we'll get a clearer sense of this dialectic of Indigenous activism that I'm trying to hopefully outline. In closing then, I believe that broader assessments of this activist generation have the potential to reorientate understandings, not only of this era, but hopefully of other historical normative assumptions. And I'd like to conclude with Fred Mahone, featured on the cover of Christian Macmillan's award-winning and beautifully rendered history, Making Indian Law. Christian texted me that he'll land tomorrow morning, so he couldn't be here today, but if you happen to see him, I think it probably put a slightly increased smile on his face to hear that his work may have been featured so prominently this evening. As we've briefly introduced already, Society of American Indian members had long felt the onerous intrusions of the federal government, and many of their concerns had also long centered on the challenges of getting the federal government to compensate tribes for the taking of their land, for the mismanagement of reservation resources, and as the LSA had suggested, for outright fraud itself. And Collier and Cohen and other New Deal leaders understood that the question of Indian land claims required clarification, and that the IRA included the IRA did include statutory provisions for extending federal recognition to non-recognized tribes, such as my own, for example, taking new lands into federal trusts for their administration, and clarifying outstanding reservation border disputes with state, municipal, as well as other tribal communities. But what if tribes whose reservation lands were seized against their wishes had not received any restitution or compensation for clearly illegal and unconstitutional takings? Fred Mahone understood this challenge, understood that his tribe, the Wallapai Nation of Arizona, who understood that his tribe's homeland had been taken illegally by the Atchison, Topeka, and Santa Fe Railroad Company, which laid its first tracks on the reservation in early 1883, shortly after the reservation had been established by executive order. The railway bisected, as this map from Christian's book hopefully can show us, the Wallapai's land, and established a watering station at the tribe's historic freshwater well at a place called Peach Springs, which you may not be able to see, but it's in the kind of center of this map, which is focused largely on the western portions of the Arizona-Colorado borderlands region. Mahone wrote to the Commissioner of Indian Affairs about this concern. He wrote that the U.S. president had, quote, set aside and reserved the use and occupancy of the Wallapai Indians, these lands. It is our desire to make this reservation our everlasting home.
for ourselves and future generations. So much like other Society of American Indian leaders, Mahone was not formally in this organization, but influenced by it. He did also project alternative visions of history that countered claims by the federal government at the time, its senators like Hayden, railroad leaders, and others, that they were, quote, mere wanderers who had no rights to their own reservation delegated lands. He suggested, as others among his tribe did as well, that they possess land rights, rights to self-govern, and formed a distinct society. He thus countered American mythologies and also enlisted the support of national leaders, including Cohen, in assembling a case that recognized the occupancy rights of his tribe. This case took a very long time, like perhaps most legal cases do, to make its way through the U.S. legal system. And when I teach this book, or can we talk about it sometimes, I try to communicate like how powerful 19th century railway companies were in America, and how the U.S. senators like Hayden were totally in line with their corporate interests, and that this tribe had literally no political representation. They could hardly afford a lawyer to file their case, which took a very long time itself just to put into motion. They had to enlist the solicitor and the Interior Office at various times. And eventually, their case did reach the U.S. Supreme Court, which I often mention was decided on which was handed down in a unanimous decision, sorry, on December 8th of 1941. In this case, called U.S. v. Santa Fe Pacific Railway Company, affirmed that the Wallapai and by extension other tribes possess, quote, occupancy rights known as aboriginal title, and that these rights predate claims by the United States and need no formal recognition. This became, as McMillan argues, quite wonderfully, the 20th century's first major articulation of Native American land rights. The court found that absent the formal extinguishment of Aboriginal title by Congress, such occupancy rights both exist for tribes and are eligible for restitution. There's a lot of legality in that paragraph that I think I hopefully communicated. But essentially, the Supreme Court handed down a unanimous decision affirming the Wallapai's rights, not just to their lands, but to restitution for their taking. And this required then a subsequent congressional statute to clarify this ambiguity of constitutional practice. If tribes' lands have been taken and they are eligible for restitution, how can we thus compensate them? Well, we're going to be busy on December 8th of 1941, right? Hopefully we can all understand what else was happening in the United States at that time and why there was no press coverage of this case and hardly any legal academic study of it until McMillan's work, in part because of what happened on December 7th, 8th, and 9th of 1941. But so the Congress eventually, with Cohen's leadership, drafts a new law, called the Indian Claims Commission Act of 1946, that established a congressionally regulated commission known as the ICC to settle these outstanding claims, establishing a nearly half-century process of congressional organized redress across much of Indian country. And over 100 tribes would file cases similar to those to the Wallapai, seeking damages and thus restitution for the taking of the reservation lands. Here is a vision that McMillan and others have kind of provided that highlights the capacity of the understudied, of the potentially rural or marginal social communities, particularly in reservation or Western spaces, to literally refashion constitutional practice. And that's what Mahone essentially was very involved in doing, and his fingerprints, like Roquela's fingerprints, are all over essentially this subject matter. This case is not commonly found in federal Indian law casebooks, nor is it the subject of much secondary literature other than McMillan's. As with the Boland case and many dimensions of these subjects, the reform of educational policy, this case was initiated by Mahone and other boarding school graduates, many of whom had served in Europe and returned home at a time of unprecedented national advocacy in Indian affairs. And they're much more concerned about this concern than getting, for example, citizenship, which we're now commemorating the 100th anniversary of the Johnson-Wheeler Citizenship Act of 1924, which bestowed finally citizenship to American Indians universally in the United States. So I hope to have suggested today that a generation of American Indian activists directed the course of federal Indian policy. It did so in part by challenging misunderstandings of American Indian capabilities. Their practices, ideas, and demeanor demonstrated a new habitus of Native capacity. And they challenged mythologies and faulty historical premises that have long undergirded U.S. historical inquiry and limited, ultimately, assessments of the rise of Native American self-determination more broadly across the 20th century, in what some scholars, I think myself included, are finally referring to as the modern American Indian sovereignty movement. I'd be happy to talk further about some of these subjects and dimensions. I didn't have time to talk about the Sherrill case, but I know Professor Davis has some concluding suggestions and or queries that might facilitate some ongoing dialogue and exchange. Thank you so much for your sustained participation and engagement.
Professor Blackhawk, thank you
Oh,
so much for joining us and for your address today. I know that we're all honored that you're here. And I will say personally, as with all your work, I've learned so much and I've been left from with so many questions about law and society from your address. So I just want to give the audience a moment to formulate their own questions. And there are microphones here and here. So if you've got a question that you're formulating, please feel free to come to the microphone, or if you prefer, we'll make sure to get the microphone to you. So I'll say, I hope everyone in the audience has or will get Professor Blackhawk's National Book Award winning history, The Rediscovery of America. Because I will say to this audience, it's a book that bears reading and rereading from a law and society perspective. Professor Blackhawk's work touches on many of the classic themes and concerns of law and society, including legal pluralism, the law in action, and law's violence. American Indians, this book shows, and as we've heard today, have been central to American history and U.S. law. And indeed, the book shows that we cannot understand each of these classic law and society themes within the U.S. context. That is to say, these themes of legal pluralism, the law in action, and law's violence. We can't understand them within the U.S. context if we don't understand the histories of Native nations that you, Professor Blackhawk, have recounted. To get Q&A started, I thought I would just take up your invitation to talk a bit about City of Sherrill. Okay. And so I'll just say to the audience that just to set that up, that for those of us that may not be familiar with it, this is a case, a Supreme Court case in which Justice Ginsburg invokes the doctrines of laches and impossibility to say essentially that too much time has passed, such that the Oneida Indian Nation, which is seeking to assert its intergovernmental immunity against local taxation, too much time has passed. The claim has gone stale. And I'm so struck whenever I teach that opinion that Justice Ginsburg apparently didn't know anything about the dialectic of Native activism that is at the core of your work and how that explains the timing of when the cases are brought by the Oneida Indian Nation. So I would really love to hear your reflections as a historian on the City of Sherrill case.
We may not have our slide up anymore, but I wanted to mention that one of the efforts that also characterized Laura Cornelius's Kellogg's advocacy throughout the early 20th century was trying to revive not just reservation
economic and kind of political capacities, raising money, taking state or government to court. But she also was trying to revive within her broad community of Iroquoian speaking Native nations, longstanding traditions of self-governance rooted in particular forms of traditional gender political practices. Her advocacy was steeped in efforts to restore traditional gendered forms of Iroquoian authority in which women had historically held much governing power and still hold to this day to select representatives to attend the intertribal gatherings of what is known as the Iroquois Confederacy, whose origins predate the arrival of Europeans and who themselves constitute the oldest political community or intertribal or kind of social community in the United States. And during the colonial era, when Iroquois men traveled and fought and were diplomatically engaged across much of Eastern North America, women held domestic and political authority within villages almost universally, and fields and resources and children, the rearing of children and certain responsibilities were inherently in their domain, and it's kind of codified in many of their kind of cultural and community practices, cultural traditions, oral traditions as well. And so women select Iroquois men to serve in important roles. And decide, for example, at times when to go to war, historically speaking. So that form of gender autonomy became heavily challenged by the arrival of property ownership in the 19th century, forms of Christian morality and other practices that increasingly kind of diminished the Iroquois values of gender autonomy and power for many women. So she was very active, ironically, given Ginsburg's larger kind of commitments to gender equity. Kellogg was very steeped in these kind of understandings of alternative forms of gender authority in which clan matriarchs govern the annual selection of representatives, for example, to colonial Confederacy gatherings. So these understandings of, I think, had amicus authors or had respondents to the case been able to expose, for example, how these longstanding efforts of restoring indigenous feminism have long guided the political efforts to essentially get land back for the Iroquois communities. I think that would have been one way to kind of counter the majority opinion that Ginsburg author that held that the Oneida could not exercise sovereignty over their lands because the amount of time had passed, and this kind of court-made equitable doctrine known as laches became not just invoked or kind of fashioned. And Indian law is kind of full of this. Professor Davis and Berger teach this, I think, doctrinally, and can perhaps offer far more insights than I might be able to. But there are so many fictions that are often invoked by American court leaders or justices in these areas, where they say, well, weren't all these tribes kind of violent to begin with? Weren't they? Did they ever really own these lands? Did they really ever use them? I think this kind of doctrine of laches isn't, as I think one of the footnotes to her opinion suggests, heavily draws upon this doctrine of discovery that is at the heart of the kind of evolving practices of federal understandings of land management, and is in the first of the most formative trilogy of federal Indian law cases known as Johnson v. McIntosh. And so U.S. justices have essentially turned to fictions of the European right of discovery to take lands from uncivilized people to justify their actions to legitimate the regulation of Indian lands in certain ways. So this is kind of one of the paradoxes of this, challenges of this subject, is that it brings uncommon subjects before individuals who often have very limited preparation to assess them. And there are very few, sadly, for example, Ivy League law schools that have full-time federal Indian law courses or practitioners. It's not a subject that is widely circulating in many kind of legal circles. So part of the hope effort of the work that many of us do is to kind of bring these subjects into some degree of visibility so that when they eventually find their way into other circles, they're not simply seen as foreign or unintelligible. There's a question here.
Yeah, thank you. And thank you for your presentation. I'm speaking as a former city council member and a former mayor, and it's become trendy to do a land acknowledgement in political context. And it's become trendy for like liberal, progressive, centrist, conservative people. And I'm wondering if because I have some education around the Iroquois Confederacy, Haudenosaunee. Not sure if I'm pronouncing that correctly, but like, that was sort of the basis of the United States government to start. And I'm wondering if there are ideas that you have that more people who are in positions of power or authority can do. And I think, the first thing is to give land back. I completely acknowledge that. But in between doing something that's very, at this point, superficial, I don't mean that it's superficial in intent from Indigenous folks, but it's superficial from politicians doing a land acknowledgement and giving land back. Like, are there specific policies or legal strategies that municipalities or uh, counties or states can pursue to more formally acknowledge Indigenous communities? And I say this coming from California, where we have a lot of unrecognized tribes, federally unrecognized tribes who still organize, who still get things done in terms of preserving land and working with environmental groups, etc. But is there more from a legal perspective that municipalities and counties can do to really sort of formally recognize and then also, where possible, actually extend more land rights to Indigenous communities who have been disinvested?
Um, I appreciate your question as well as your kind of concern that the somewhat performative nature of certain political practices seemingly is divorced from perhaps more applied practices or actions. I think it's helpful as a historian to take sometimes contextual perspectives on subject matters and to understand that we are living through a kind of new era of awareness around these subjects. 10, 15, 20, 25 years ago, these were not common conversations. And only recently have some of the most egregious, perhaps representational challenges or confronting American Indians that have often been kind of denounced by professional organizations or academics like the American Psychological Association that have highlighted the harmful impacts that negative representations can have on children. Only recently have some of these, for example, mascots come down or been changed, or recently state curricular initiatives have put American Indian history into the required subject matters for K through 12 school systems. I think understanding this kind of trajectory is helpful to understand that there have been significant gains in certain ways. Challenges obviously remain, but that there will be, with dialogue, with engagement, with understanding, potential strategies for collective action that might present themselves. And I think it's hard for people who are outside of the field, and I'm not actually a law professor, so I don't really uh, know the dimensions of contemporary law practice. I'm much more familiar talking about, I don't know, the Colorado Gold Rush of 1858, which I actually wanted to mention today. One of the best books on Colorado history is called Contested Plains, which is kind of very congruent with your conference theme. And it opens, it kind of has this really interesting section on the Colorado Gold Rush, which kind of led to Denver's formation. So I can't really answer some of the kind of particulars, but I can say that within the field of federal Indian law, like this Wallapai case, which like I never had heard of it until I picked up this book. And to be honest, there's a funny, crazy story to this that I love telling my students, but I won't bore us with too much, except to say that one of my promotional requirements at the University of Wisconsin from associate to potentially full professor required the need for an international publication. And I'm thinking, okay, I study Native American history. How am I going to do this? And then somebody offered me a review essay in a journal of American Studies in Australia. And they offered me Christian's book. And had I not taken that review, I would not know about the Wallapai case because I may not have spent that much time. So within this subject are these types of already evident opportunities of engagement, essentially. There have been monumental class action litigations that have changed Indian community kind of political and financial fortunes. There have been tremendous, as you know, from California, relatively recent, historically speaking, gaming powers that tribes have obtained, contested often by state governors or leaders who were either unfamiliar with or threatened by these initiatives. We're living in a kind of different topography, essentially, of Native America and kind of U.S. white relations, a field that it used to be known as, in which we still need to kind of bring people kind of into some of its kind of core tenets and practices. One of which is that tribes are not exclusively racial communities, but political ones. They have governance, as you know already, but many may have less familiarity practically with governance over their lands. State jurisdictions do not extend to them, largely except in certain criminal areas. Municipalities can work in partnership with tribes, but need like MOUs or cross-deputization agreements of various kinds. But just understanding these kind of already existing practices and or evolving ones might be one realm of possible further engagement rather than simply a representational or kind of performative kind of beginning to a public hearing of some kind.